Hello entrepreneurs, Michael Moore here with Argent Place Law, the law firm for entrepreneurs. As I record this, the United States is just getting involved in the coronavirus. There are several states and quite a few local municipalities that have locked down their citizenry, saying you can't have events you can't attend events that are more than 50 people. Some cases even 10 people. You're not allowed to go to restaurants and bars. What if you're caught up in something like this? You can't perform some aspect of a contract that you're obliged to perform because of these kinds of governmental restrictions. Well, I suggest you pull out your contract and look for a clause that's typically called force majeure. It's a French word, and it means a French phrase that means major force, of course. And it talks about what happens if something outside of your control makes it impossible for you to perform. Let me give you an example of a typical force majeure clause that might appear in an independent contractor agreement. Neither a party will be liable to the other on account of a delay or failure to perform as a result of act of God or other natural disasters or anything else that's beyond the reasonable control of that party. Should such an event occur, the affected party will promptly give notice to the other party and take all reasonably commercial efforts to minimize the impact of the event. So, if you have a situation in which you cannot perform, you need to evaluate that and tell the other party why you can't perform and take reasonable efforts to minimize the effects of that, the damage due to that, the damage to the other party. So example, I'm an attorney, and I've been paid by a client who wants me to review contracts for him. Well, I don't have to go to a public gathering. I don't even have to go to my office, although I do. I can perform sitting at home in my jammies, and I do that sometimes. So I can't invoke a force majeure clause, but if you have to plan an event for a customer, and in order to pull that event off, you have to have a couple of dozen of your own people there, you can't do that. In fact, the event can't even take place because you're probably going to be more than 50, there might even be more than 50 people at the event. So you would have to tell the person, the group, the company that purchased your services that you cannot perform. They're in the same boat, they cannot have the event. So there'll be a mutual meeting of the minds, maybe the event will be postponed, etc. So let me now read you an example of a contract in which the force majeure clause doesn't really very well protect one of the parties. Neither party will be liable to the other for any delay or failure in performance due to labor disputes, strikes, natural disasters, or anything else beyond the reasonable control of that party. Provided, however, that this section does not excuse the tenant from the prompt payment of rent. This is a commercial lease, and it says the landlord gets paid no matter what's going on out there in the world, no matter what natural disaster, no matter how sick you get, or you can't bill your customers, you have to pay your rent. We reviewed dozens and dozens of these kinds of leases, and I did a quick check of them, and all of them either don't contain a force majeure clause at all, or the force majeure clause contains an exception just like this. So, what situations would you be able to invoke force majeure? Well, it's highly fact dependent. So I would suggest that if you find yourself in a situation where you're going to have trouble performing your portion of the contract, then you should call up your lawyer and ask him to review it with you and see if you should then notify the other party that you can't perform. I'm Michael Mort with Argent Place Law, the law firm for entrepreneurs, where we believe that entrepreneurs are going to save the world, even perhaps the coronavirus problem, and we want to help. Thanks for listening.